I accept that. That goes back to my answer to the first part. I accept he probably doesn't.
Does it matter for these purposes that it's effectively he's trusting a jury of 10,
Yes.
and 10's not a jury within the Jury Act in Jamaica, is it?
One then gets into what I call a rather metaphysical argument about what is a jury. Clearly, it's 11 people who walk into court. I go back to what I call the first question. Is it really the case that there is no jury if it turns out afterwards that one of them had taken a bribe and was going to acquit come what may?
That's if it turns out afterwards.
Yes.
What if you know going in?
If you know going in, I submit the same follows. The judge is entitled to say this. A 10-1 verdict is a good verdict. It's authorised by law. I have good reason, I'm just, as it were, expressing in words what no doubt the judge would be thinking. I have good reason to trust the 10. They will follow my directions. That is good enough to satisfy the requirements of the statute, that there be a jury who decides this. Because there are 11 altogether, and if there are 11 altogether and one of them still takes no notice of what I say, well, so be it. But my Lord Lordbury put the point at the beginning. It's quite a short point, but quite an important point. But I do submit the crossover between these two questions does arise, but I suppose it's very important to keep them separate. Because if I'm right in saying that a verdict by 11 men, or 11 men and women, one of whom is bent, is a good verdict at the time, then that's a good verdict. If, on the other hand, it's clear that there's a real risk that the 10 might have been influenced by the one, then I accept. That might be a basis for setting aside the verdict.
Just starting with the one, you say that the judge can choose to leave somebody on the jury, notwithstanding that he knows this person is corrupt. Presumably it's the same if he knows that the juror is mentally ill or communicating with the deceased via a Ouija board or has been looking up the internet. It's the same, is it?
No. No, my lords, it wouldn't be the same. If I may, no. The important point here is the prosecution knows the problem, and in the passage I took you to, the prosecution says, we're the ones taking the risk.
Well, but they can't waive the public interest in the administration of justice. It's not a matter...
Well, the difficulty, my lords, if this had happened on day one, it would be a very different position, obviously.
You're really just postponing the question. So, on your view, can the prosecutor decide that it's okay to allow somebody to remain on a jury, notwithstanding all the scenarios that I've put to you, and the judge can go along with that?
In my submission, in the extreme circumstances of this case, yes.
And how many jurors can the judge allow to remain on the jury, notwithstanding his knowledge that this one's mentally ill, that one's been bribed, the next one's in touch with the deceased via a spiritualist?
Well, no, of course, he can't. The whole problem in this case arises because there were just 11 left. That is where the problem arises from. And my lords, of course, I can see one can think of any number of examples, like the Lordship is putting to be saying, well, in those circumstances, surely the prosecution couldn't just waive it. But this is rather different. This is right at the end of the trial, enormous expense, 56 days, the evidence has all come out, the summing up has been done, and then, boom, one thing comes out. Now, in my submission, the question is simply this. I mean, it does get to this point. If I'm right in saying that a verdict of a 10-1 verdict of 10 good people and one bent person is a good verdict as a matter of law, then the judge is entitled, and the prosecution is entitled to say, well, I dare say that person won't obey his oath, but I'm satisfied the other 10 will.
But that's assuming there's going to be a conviction. And the jury has, if it's going to acquit, is going to have to do it by... Is it an 11-person jury is going to have to do it by a 10-1 majority? And how does the judge know? Well, it's likely that there will be 9 good people and true and 1 crook in the 10. It's an acquittal.
Well, my lord, if in my submission the judge, the fundamental right is to a fair trial for the defendants. If the prosecution, and in one sense, this whole case comes down to one point: can the prosecution say, "I know there is this one person who seems to be offering bribes. We probably can't trust him, but I'm prepared to carry on and take that risk"? Is it open to the prosecution to do that? That is the question. That's what the prosecution did. And in my submission, the answer is yes. There's no authority, if I may with great respect say, that says, no, the prosecution cannot do that, because that would deprive the accused of an unfair trial. I also make this point. The question is not, so to speak, at the very moment this all takes place, but looked at broadly, looking at that verdict. Have the defendants received a fair trial? If one is satisfied the 10 were not influenced. I agree, obviously, that's the separate question. But assume for the moment that the 10 applied with their oath, they acted properly. Is it really to be said that that was a bad verdict and the defendants must be acquitted or the appeal must be allowed? I submit no. That, I do firmly say that would bring justice into disrepute. 10 people have done their duty, one person has messed it all up, but the verdict is a good verdict at 10-1. Why does it matter if the one has brought disaster? That brings the jury system into disrepute. Our learned friends, of course, rightly say that in England we don't have that problem. But this is a common law point. And the question is, what is the common law in this situation? And that's why I urge upon your lordships the point that I'm making. I fully accept you've got the separate point about who knows what was going on in the back of the jurors' minds. That's a different point. But my point is just on this, what you might call the degree to which there have to be 11 people on the jury. The fact is there were 11 people on the jury. That is my short answer to this. One of whom, at the time, there was good reason to suppose wouldn't act properly, and who we now know didn't act properly. I submit that's not a conclusive answer. And it would
Can I just take you to, where we got to, I think, which was paragraph 25 of the Bonnet-Taylor decision, page
yes.
6291.
Yes, thank you.
Lord Hope very clearly says that the direction which the judge gave in this case was clear, understandable and to the point. And we look either earlier at what was being put forward as the defence, as the direction.
Yes.
Don't allow anyone that you sat or sitting with about some prior knowledge or feeling or view, that's unimportant. In other words, he's directed the jury to the specific problem. Now, just to say you've got to carry on with your oath seems to me non-specific. It is not to the point. It doesn't make clear to the jury precisely what the judge is wanting them to do.
In my submission in this context it does, because they will all know there's been this half-hour break in the summing up while form has been called away. She will have told them, because the judge says, tell the others. She will have told them what's happened. And, my lords, I fully accept, of course, one might say the direction could be more forceful. I accept that. But the question is, was it sufficient to ensure the fairness of the trial, given everything else which I've mentioned? And in my submission it was.
But all I'm saying to you, putting to you, is that what was said by Lord Hope hardly supports your case, because this was not a specific direction.
Well, my lord, not express. I don't want to, as it were, quibble. I accept it was not specific, and of course it would have been better were it this specific. But the question is, was the direction given by the judge taken together with everything he had already said, and the juror's sense of responsibility, was it sufficient? But of course this is a different point. My submission is it was, in one sense. I take your lordship's point. It's not specific in the way this was, but in my submission it was sufficient.
Could be. I'm not sure that it. I think you probably have dealt with this point, but it strikes me. But when you say this is a question of common law, I don't think it's purely common law, because we do have the statutory provision.
Yes.
It's on page 6803.
Yes.
Which tells us that 12 jurors form the array in a case of murder, and then says in subsection 3, where in the course of a trial